Hi everyone, Armine Bazikyan here from Bazikyan Law Group. In this month's video, we wanted to address the question of how long it takes to probate an estate from start to finish with an attorney versus without an attorney. I think this distinction is really important to understand so that you can know exactly how much time is spent during the probate procedure with one scenario versus the other. It'll help you make an educated decision. So let's jump in. As we've discussed in the past, a probate is what happens when a loved one passes away with a will in place or without having done any documents at all ahead of their death, before they've passed away. And therefore, the assets that they own are being funneled through a court process called probate. Now, this process is traditionally very, very lengthy, and we've experienced an additional time being tacked onto this probate process because of COVID, as well as the post-COVID backlog of cases that the court has had. So because of COVID, things were delayed, and in a nutshell, now the court is playing catch up. So what would have been a very traditionally long process is now even longer. So with that in mind, we want to jump in and talk about what the difference is between doing it yourself, not hiring an attorney, and actually hiring an attorney and having them guide your case. So as with everything, the real big difference here is that when you hire an attorney, the attorney already knows the procedure, presumably. The attorney already knows what they're doing, and if they're knowledgeable in this area, they're going to be able to guide your case from start to finish without any issues. Now, this is really important because with probate, the judge, the court staff, the people that are involved on the court side are not allowed to legally help you. And I see this in the cases when I go into court. When I go into court, I see this happen all the time, where it's an improper person, which basically means that it's somebody who is not represented by an attorney. They're representing themselves, and they come to court for a hearing, and they appear in front of the judge, and the judge says something like, I don't know, the notice, have you served notice? And the person's like, Your Honor, I don't know what notice is. And the judge is like, well, you need to serve notice. There is a missing component to your case, and it is the notice. And the person will ask, well, how do I do that? And the judge says, I cannot help you. I cannot represent you or be an attorney that represent you. You have to do it yourself. So the court is actually limited in what they can and cannot tell you during that court proceeding. So it's not that they don't want to help you or they don't want to help your case move along. It's just a simple fact that they are not legally representing you. They're not playing attorneys. They have to be a neutral third party. So they can't actually tell you like, oh yeah, a notice, it's just a piece of paper. They want you to be able to notify everybody involved that this case is pending or this hearing is going to happen. That's what it is in a nutshell. So they won't be able to give you that very basic explanation of what notice is. So what ends up happening is this improper person is done with the hearing. The judge agrees to push the hearing out by a month to give them enough time to provide notice to the other beneficiaries or heirs, but the person doesn't know what they're doing. So they go, they scour the internet, they think they figured out what notice is, they do it, they might do it incorrectly, and then at the next hearing, there's a defect. Like, hey, you served notice, but you didn't do it in proper timeline, or you didn't address it correctly, or so there's some other defect in your notice. So then we have an extension of that hearing date again by another month or 2 months. So all of these extensions of hearing dates, because of the lack of knowledge of the improper litigant or the person petitioner, causes an extreme delay. So anytime we have somebody self-representing or representing themselves, we always see at least a year, based on my experience, tacked on to the normal course of a probate proceeding. Whereas if you're represented by an attorney, all of these learning curves are going to be eliminated because the attorney's office or the attorney is knowledgeable about the case, knowledgeable about the area of law, so they'll be able to funnel your probate case from start to finish with ease, hopefully, and get it done within a year to about 2-year timeline, which is pretty standard if there's no conflicting issues in the probate case. The shortest amount of time that a probate can be opened by minimum is 4 or 5 months. There is no way you can get a probate done in California in less than 4 to 6 months. We have a 4-month holding period for creditors' claims, and it takes about a month to file and get your petition and your letters actually of appointment to begin with, to start the case. So I would say minimum it takes 6 months. With an attorney's office, you're looking at about a year to 2 years on average. Without an attorney's office, which is the question we're here to address today, you're looking at, in my opinion, based on the improper litigants and petitioners that I've seen, you're looking at about a year and a half minimum, all the way up to 3, 4, 5. I've even seen probate cases pending for 7 years on a small technicality that could have been resolved. So, lesson here at the end of this question. The lesson to be learned by this video is that always hire an attorney to do it. Don't hire a non-licensed person because, again, we've seen in previous videos where that leads to problems and that leads to an additional time being tacked on. Do your homework, hire a professional, hire a licensed certified attorney in probate to be able to help you. I know that it's costly and you're trying to save some money, but that ship sailed when the deceased loved one failed to do their documents ahead of time. Your objective is to get in and out of probate as soon as possible. A lot of times we have property involved, we have mortgages involved, we have creditors' claims with accrued interest. So what you think you might be doing to save money might actually be costing all of the beneficiaries a lot of money in the long run. So be very careful with the steps that you're taking. Make sure you're hiring a licensed certified attorney. As always, we're happy to provide a free consultation. Feel free to reach out to our office at any time, and we'd be happy to sit down with you and chat about your matter. Have a good one. Bye-bye.